Very happy, very excited to welcome Attorney Meng with us once again. I think we have been doing these kind of events with immigration attorney Marta Meng for like at least 2, 3 years. So we know each other very, very well. And she's one of the most trusted attorneys that we refer to our clients, our students. So today we will be focusing on, the new interesting things. We will be surrounding our topics with Trump getting elected and becoming the new president in the upcoming year. We're going to focus on some of the categories of the visas, for example, student visas, work visas, what has been done in the past when Trump was the president, and what might be coming when he becomes the new president. So, if you do have a questions, as I mentioned, put it into the Q&A. If we couldn't get to a question yet, feel free to scan the QR code. You can always talk to our consultants, or we can refer you to the attorney. Before I begin today's session, I want to briefly talk about who we are as the organizer. We're GoElite. We're located in Los Angeles, Pasadena. We are a education consultancy. We work with lots of accredited U.S. universities. Our primary service would be Day 1 CPT university applications. We do help out with students' urgency cases, for example, F1 reinstatement, change of status, and emergency transfer. Our mission is always to make our students' American dream come true. And then we're certified by ARC as one of the most respectful organization in the education space. So moving forward, I wanted to introduce our two brand new projects. The first is the reward program that we built for Day 1 CPT community. So we will send the link to you in the chat. And if you register to these rewards, you will be able to claim some rewards and get some gifts from those reward points. And the second project I wanted to share is our white book for F1 students. This is what we wrote ourselves in our inner team. We focused on a lot of topics that will be beneficial to F1 students because we were all F1 students a point when we come to the US before. So it will focus on visa, housing, healthcare, and a lot of other things. So the ebook is free. Feel free to also access the link that we will be sending to you. We are also on Google reviews. Feel free to check us out. We have more than 500 five-star reviews. See what other students say about us. And finally, we're on all social medias. We're posting daily, weekly, surrounding Day 1 CPT and more. So definitely follow us on all the socials. And without further ado, I will stop sharing. And then Marta, you can share your screen.
All right, thank you very much, Ryan. Thank you very much for having me here today. And thank you all for attending today's webinar. So as we were about to start the presentation, some of you may have already learned from some of the news that there's actually a new rule coming out today. That's a final rule on H1B. So this is not something unexpected. I believe we might have already mentioned this new rule that we are expecting to come out before the end of the current administration, and it does get released before the end of this administration, which is good. So the new rule is going to take effect from January the 17th next year, 2025. So it's going to take effect before the Trump administration takes office. And because this new rule has been through the whole rulemaking process, so it won't be rescinded like the first day when Trump takes office. So we do expect this new rule to impact next year, especially next year's cap H1B petitions. But that's not going to be the focus of today's session. We might have another session just dedicated to this topic to focus on all the changes in this new rule, how that's going to affect next year's petition. So stay tuned. So for today's topic, it's about what to expect, right? What to expect in the second Trump term, like the Trump administration. I saw this topic prepared by GoElite. It's like how difficult will my immigration journey be? It seems like it just everyone already assumes it's gonna be difficult, right? It's just like how difficult. Well, we all know that, during the 4 years of the first Trump administration, yeah, there were a lot of changes, including a lot of changes affecting international students, all kinds of employment-based petitions, and of course, some of the public charge rule, which are affecting the family-based petitions, also humanitarian programs. Would that gonna all come back? To be honest, we don't know. We don't know yet. Nobody knows until the new administration starts working. So what we're gonna do today is that we're gonna do some projection based on what happened during the first Trump administration, what happened during the recent, the campaign trail, like what's said, by some of the Trump allies or advisors. So we're gonna make some projection based on that. But whether that's all gonna be implemented, whether all those proposals are gonna all materialize into actual rules, we will see. We don't know yet, but so that just we have some idea what to expect. Okay. All right. First of all, some disclaimer. The content today is for educational purpose only, and it is for your educational purpose only. So whatever you watch today, please save that for your own, reference. Please do not pass this to a third party. Do not upload to social media or any accounts without our consent. And anything in this presentation is general information because I don't know your own personal case history. So whatever information, including the Q&A session, is general information only. That's not considered legal advice until there's a separate written agreement signed. Okay, something about myself. My name is Marta Meng. I have been practicing for 12 years now. So I did practice immigration law during the first Trump administration, so we went through all those changes, in those 4 years. I am based in Los Angeles, California, so Southern California. But, as immigration law, especially for employment-based immigration law, it's federal law, so we can represent client nationwide. I am a certified specialist in immigration law by the State Bar of California. I am, the current chair of the immigration law section of the Los Angeles County Bar Association. So we mostly specialize in employment-based petitions, work visas. So that's our specialty. That's what we focus on. While working on those work visas and employment-based petitions, we deal with the student status a lot because a lot of those filings are from students who are currently in the US. So if you have any questions related to all these, student status, work visas, employment-based petitions, feel free to leave that in the Q&A. We will address that at the end of the session. Okay. All right, so that's going to be what we will cover today. So we're going to be talking about some of the main policy updates from the Biden administration. Because in order to understand what to expect next, right, we need to understand what has already happened in the past 4 years. What has the Biden administration done for, a lot of the international students? So maybe the Trump administration will undo some of those, or maybe all of them, or maybe none of them. But we need to know what has been done in the past 4 years. Initially, I plan to talk about some of the rulemakings we expect to be finalized by the end of the current administration. But, by the start time of today's presentation, that rule has already been released today. So we're just gonna briefly talk about this final rule on H1B. And then we're going to be talking about the second Trump administration, mainly focusing on those are relevant to international students. So mainly the different types of work visas. So what kind of changes we expect in different categories. Okay, so those are going to be today's agenda. So let's get it started. Okay, so this is what has happened in the past 4 years from 2021 through 2024. Of course, there have been a lot of other changes, but I picked a couple that I feel most relevant to today's audience. So mostly those changes affecting the like the work visas or immigration petitions. So some of the good changes, including the AI initiative. So during the Biden administration, there has been, a lot of White House announcement, announcing that the U.S. wants to retain the talented people to work in the AI field. So that started back in 2022, the beginning of 2022, and it started with, some of the announcement, aiming to favor people from STEM major in NIW and in O1. So we did see the adjudication on those cases with more relaxed kind of adjudication, at least throughout 2022. However, maybe because of the relaxed rule, so there were too many fillings. So starting from 2023, we have seen, USCIS somehow tightened the adjudication on NIW, even for those STEM majored petitioners as well. So it goes like, it's really good, and then it goes down a little bit. But the overall theme is it welcomes people in the AI field. So that is, something happened in the past 4 years. So it's done not one time. So let's say for EB1A, USCIS has released at least like 3 policy updates regarding EB1A. Of course, that's just policy updates. So it doesn't change the law itself, but it relaxed the way USCIS interprets the criteria for O1, for EB1A, and for NIW. Especially for O1, because as we know, H1B has a really low selection rate, right? So it's probably somewhere between 25% to 30%. So that's the selection rate, even after this year's like online lottery reform, right? But still, the demand is so high, but the overall quota is fixed. So the selection rate is somewhere between 25% to 30%. So for those unselected beneficiaries, they have to look for other ways to stay and work. And O1 has become a very popular option. There is no annual quota, right? So there is no lottery, but it is only safe for those who can prove they have extraordinary ability in the field. So the O1 criteria have been interpreted more favorably for the applicants. So that is something worth mentioning. Okay, but on the other side, we have seen like there has been these like DOJ, Department of Justice investigation on a lot of the big tech companies, and in 2021, I believe, at the time, Facebook, now Meta, entered a settlement agreement with the Department of Justice. And also there was some investigation from the Department of Labor as well, right? So that led to the suspension of a lot of the PERM, the labor certification sponsorship program at a lot of the big techs. So like for those of you who are in the tech field, you might have heard a lot of those big names, right? They have stopped sponsoring people for the labor certification for perm. But that is a big problem because for those who might not at that kind of like who are good. I'm sure those who can stay in the US are all very bright young people. They are bright, they have studied hard so that they can get into these big companies, but not all of them can show their own like impact to the field as an individual, right? Not all of them are with like say a PhD degree, so they might not be able to do EB1A or NIW for themselves. So a lot of them rely on the company to sponsor them. However, because of the suspension of the perm program, a lot of them really have no way out. They are using their maybe H1B status, but they cannot see the hope to get a permanent status in the US if the company doesn't sponsor unless they change job. So that was very unfortunate, and that also happened during the Biden administration.
Marta,
So
do you mind if I jump in to ask you a
yeah,
question?
of course.
Speaking of that topic, I think a lot of our audiences here know that this kind of perm bans are still existing in some companies. And
Mhm.
then we do want to understand a little more about the whys behind why do they stop issuing perms, or why do they pause those applications? And why do you think particular is with those big tech companies? Or is it more universal to all companies, or are just the big tech companies are being targeted?
That's a great question. I would say this standard should be applied to all. So it's not just the big tech, but they usually sponsor more people,
Mm,
so they're bigger targets, right? So if the government is gonna go after somebody, they probably want to go after the big guy, and for the all these settlement, just for sending the message out,
mm,
that would be more effective, right? But it doesn't mean the small companies are not affected at all.
mm,
Maybe it's just a matter of time, after those big ones are targeted first, then maybe the small ones would be the next object, the next target, or maybe not. We don't know yet, but definitely because those big tech companies are the ones sponsors the most
right.
perms. So they are definitely the top one target for the government to go after.
Abs-
It's a little, I would say, as an immigration lawyer, I can sympathize with those big techs because what they did in the past was totally in compliance with immigration law. They did all the ads as the INA, as the CFR, as all these laws and the regulation require for immigration purpose. So it's not like they directly violated some perm related regulation. So they did do all these ads. However, the government was accusing those big tech companies of not treating the US workers fairly during that recruitment stage. That's also a little controversial. Some of the immigration lawyers, to be honest, myself included, I don't think that's a very fair way to compare because the recruitment steps in the perm cases are not meant to hire anyone. It
mm,
is a labor market test. It
mm,
was to show that they complied with all the like the ad posting requirement,
mm,
but then there's no minimally qualified US workers. So they can proceed with the sponsorship for the foreign workers. So even if they had found a qualified US worker, they are not obligated to hire this person. All they need to do is to stop the sponsorship, wait for 6 months, and resume. So that's what they need to do. They're not obligated to hire the person found. However, the government comes back and say, when you're doing the like to the big tech companies, when you're doing all these ad postings, even though you might have complied with the perm regulation, but you are not doing it the same way as your usual hiring practice. So when you hire, people, you would post in other channels like your internal system, right? Or something like LinkedIn or Indeed. Like, but when it comes to perm, you're doing like the very minimal. Like you're posting on the government website, right? You're posting on newspapers. So it's unfair. You're not posting them at the right place. But that's where the controversy is. But they're not required to by the perm regulation, right? They still comply. That's how they got those perms approved in all those years. But now the government comes back and say you are doing it differently from your usual hiring process. But it's not a hiring process to begin with. It's a labor market test process. And also for the perm ads, employers are not required to put a lot of requirements there. They are supposed to put the minimal requirement.
Mm,
Even like say even they prefer a master, but if the minimum is a bachelor degree, they can only put bachelor degree. So that's how you should do the perm. So on one hand, employers are only to list the minimal requirement in the perm, but on the other hand, they have to now they are told by the government to post it the same way as their usual hiring practice. I feel like it's a little double standard, But anyway, none of them really fought back. They all settled, including Apple, including Meta. So that's what it is. So yeah, so that's why we're seeing these suspension of the perm program.
yeah,
Okay.
thank you so much. I think that makes it very, very clear for us. I think a lot of us are at one point wanting to get our perms. So this is very good information for all of us.
Sure, sure. I'm glad. Okay. And then, today we saw this new rule about H1B published on the government website. There are quite some changes. I'm not gonna go through all of them, but I picked a few I feel like most relevant to today's topic. One of them is about requiring the inclusion of the beneficiary's maintenance of status document for all employment-based extension or amendment of state petitions filed with USCIS. Um, to be honest, I feel like that's not on the face, it doesn't look like that much a change. That's already being implemented right now. But I feel like the Biden administration kind of wants to codify them so that they require the petitioner to submit all these documents upfront instead of like waiting for USCIS to issue a request for additional evidence. That means, for anyone who wants to change status in the US, you need to prove the status maintenance documents, from the last time you enter. So all these status maintenance documents. I know a lot of you are in F1 status, right? And some of you might be still in school. Some of you might be using OPT. Some maybe during the 24 months STEM OPT extension, and some of you might be using CPT. So keep in mind, with this new rule, I feel like that's my guess based on what I've seen in the past and what the new administration could do is they might ask for more status maintenance documents from the beneficiary if the beneficiary is in the US and is requesting to extend or change the status. So make sure you have all those documents ready to have a smoother filing process. Okay, the other is about the automatic extension of the cap gap. If you are in a student status and your H1B petition is filed before your current status expire, then your status would be automatically extended currently until September the 30th, right? But now it's going to be further extended to April the 1st of the same fiscal year. That makes a lot of sense because the H1B filing process has changed a lot given the new online registration process, right? So we have a filing window now between April through June, and if there's a second round of lottery, it can be sometime until November. So extending cap gap only like through October the 1st doesn't seem to work that well with the new filing schedule anymore. So it's really good news that it's extended through April the 1st. So a lot of people, a lot of the companies don't have to sending that $2,805 for the premium processing anymore, right? Because right now a lot of them do sending that additional expedite fee to get the decision sooner because the person's cap gap will expire soon. And one other big change is about those nonprofit organizations that can qualify for cap exemption status. As we know, like not all the employers have to go through this lottery process, right? Only those that are subject to the annual cap. But there are some employers exempt from the annual cap. And one big group of those employers is the nonprofit organizations. But not all the nonprofit organizations are exempt. I would say two very distinct group would be one is the universities and the colleges, right? So they're definitely exempt. The other would be the nonprofit research organization and also the government like the governmental research organizations. So the key word here would be research, right? What is considered research? So the current policy is that in order to be considered for the cap exempt status, the organization, that nonprofit organization, has to be primarily engaged in research. That's a very high bar. A lot of the nonprofit organizations, they might be doing a lot of things. Maybe research is part of their function, but not a primary one because they might be providing service to the community. But right now, it changed to fundamental activity. You can have a lot of fundamental activities, right? But you might have only one primary function. So that would allow a lot of nonprofit that may not be qualified as cap exempt organizations to be able to sponsor H1B without having to go through the lottery. So if your employer is a nonprofit, definitely look into that. I believe that can benefit a lot of the organizations and beneficiaries as well. So I just picked three. There are way more changes. So we will have another session to talk about that.
Yeah, speaking of that topic, because this news just came out today. Well, both of us learned about the new rules officially launched today. So I do wanted to launch a poll for everybody that is here, since we wanted to put together another webinar focusing on this specific new rulings for H1B. If you are interested in H1B or if you're not, let us know in this poll and then we can kind of see what we wanted to talk about in the future. All right, let's just continue. I'll leave it for like a minute, and then once everybody sent their answers in, we can go back to that.
Great. Thank you, Ryan. Okay. All right. Speaking of the student status, I know a lot of students who are using CPT or have used the CPT in the past are very much concerned about the risk of it, especially given some recent media coverage by, a mainstream media, Bloomberg, right? Like the Bloomberg October report covered CPT. That's very unusual. I feel like that is something very well known in the immigration law like field, right? Like a lot of the practicing attorneys are aware of this type of work authorization and a lot of the trends and issues with it. But it never really got that much attention from the mainstream media. I would say maybe this is to me at least, I feel like this is the first time a mainstream media has had this kind of really detailed news coverage for this topic. So, it did a lot of research on like what kind of schools are offering CPT, why are they getting so many enrollments in recent years. So because of this report, we have seen a lot of students very concerned, very anxious about the use of CPT. But I would say, if you go to this report, read it through, you will see that it's really about compliance eventually, right? So it definitely talked about like schools. Sometimes, they're struggling. They want to get more enrollment. So, it's good for the school's financial well-being, but at the same time, they need to stay compliant, right? So where they can find that balance. So it's not like all of these schools are bad. That's not what this report is about. So it is really about first the compliance on the school side, whether all of these schools has been compliant, right? Like, do they have a good record of student attendance, like of in-person classes, right? So that would be one of the consideration for the schools. And the other is how good are they at like making the curriculum like compliant with the regulation. So those are the things that school has to worry about. On the other side, it is really the individual students. Like you need to make sure you stay compliant as well. Let's say worst case scenario. Worst case scenario is if one school somehow at some point got into trouble because they don't keep a good record of their students' attendance. All right. Then what's going to happen next, right? Then most likely USCIS would ask these students to provide their own enrollment attendance records to show their attendance at the school and their maintenance of the full-time student status. So for everyone, make sure when you are at school, you should still, attend the school full time, only work when it is during the authorized period, right? And then that should be related to your major. And when attending school, make sure you have some in-person attendance. It can be all online right now. It's already post-COVID. So if it's purely online, that's going to be problematic. So I would really encourage you guys to read it through so that you can get some idea, what are the real risk about it. So yeah, so that I like according to this report itself, it also admits, this is something legal, at least, in the law, but how it's implemented is something that's worth monitoring. So to every student, make sure you are using it legally, the any work authorization issued by school. Okay. Um, and then before we start going over some of the changes to expect, uh, I'm gonna bring back this slide again. I have used this slide in the past when we talk about, applying for the green card, just to clarify, maybe some of you don't know yet that whenever we talk about status, we wanna first separate them into two groups. One is some of the temporary status, some of the temporary work visas. So those are not green card, but when those are granted, you can stay and work in the US immediately. So that's why a lot of the students will still need these work visas. So you need something to take effect immediately after your student status ends, right? The other group is about the green card application. The green card is a two-step process. You file a petition first, and then after that, you file adjustment of status. The form number is I-45, right? To apply for adjustment of status in the US. Adjustment status into what? Into the permanent residency. Under some circumstance, you can file the petition and the adjustment of status concurrently, but not for all. Only if your category doesn't have a visa backlog. Let's say immediate relative of US citizens, right? So if you're married to a US citizen, there's no visa backlog. You can file the petition and you can file the adjustment of status application at the same time. However, if you have to file the petition first, wait for your priority date in the visa bulletin to be current, then you are not allowed to stay merely because you have the petition filed. You still have to find other ways to stay in the US legally. That's why you need all these work visas, right? For some, especially a lot of you guys are from like say mainland China or India, though like the wait time for a lot of the category are pretty significant. So while you're waiting, and before you can file for that adjustment of status, you will need those work visas. So those are two very different concepts. So I want to clarify a little bit before we go over them. Okay. All right. So what to expect in the second Trump administration, especially for work visas and employment-based petitions? Is that gonna be all the same, old like policies from the first Trump administration again? We don't know yet. It could be, but there has also been these reports like this one. This is a report done by Political released this month, right? I like the title. It's like Elon Musk versus Stephen Miller. Right. So it's really about their battle. Okay. So it really matters most to, international students and work visas. Who's gonna have the final say in those policy making during the first Trump administration? So Trump 1.0, right? Stephen Miller was the guy who was behind all those anti-immigration policies. He's back again. Now he's the deputy chief of staff on policy. So he's gonna still have a lot of influence on immigration policy for sure. But this time, looks like there's someone else there also may have some influence, right? That is Elon Musk and a lot of the tech companies, right, from the Silicon Valley. So according to this report, those tech companies are working really hard, sending a lot of lobbyists to try to get some immigration policies that would be favorable for, like those talented workers they want to keep, right? So at least this time, there's some balance here. It's not like all Stephen Miller, but how this is gonna eventually play out, we don't know yet. But I want to be optimistic. Hopefully it won't be as bad as the first time, but we don't know yet. There's so many factors playing into it. So we will have to wait and see how it's gonna be like, what are they gonna do eventually. But I would say this is something different from the last time, at least for a lot of the work visas and student status. Okay, some of the status that are most relevant to international students, including F1, right? So F1 during the Trump 1.0, it was definitely under a lot of scrutiny. And the way like say the DHS was tightening the policy for F1 was through more strict compliance requirement. So for any of you, who are like say working under OPT, make sure you report your employer timely. Report your address change timely, because toward the end of the last Trump administration, they started sending out notice to students when they found some gap in the student's work history. So like they would send out notice to the students, say, we're going to terminate your service because we notice you haven't reported an employer and it's been over 90 days. So as a student, make sure you keep your service record updated timely so that there's no this violation, allegation toward you from the government. Um, to be honest, I feel like during the Biden administration, the student status has also been under a lot of scrutiny. I don't think it's really relaxed a lot. And given this new rule, like the final rule on H1B, it talks about, including the status maintenance document. I feel like this is going to be going into the new administration for sure as well. So there are two types of like say review, right? One type of review is when the USCIS reviews your status document when they're adjudicating a benefit you are requesting. Like say you want to change it into another status, that's when they want to ask for your status maintenance documents in your current status. Another is they may do that even more proactively. They're going to look at the service record and proactively send out notices asking people to submit documents, or they're going to close the file. So that's possible too. And then there's the H1B. H1B approval rate dropped 20% during the first Trump administration. So it was a really badly like targeted visa type in the last 4 years. I mean, during the first 4 years of Trump administration. Um, Now that this new rule is released, we don't know how the new administration is going to interpret. They can, if they want to be, like business friendly, they can use this new rule to save a lot of the work, right? Including the deference policy. They don't have to re-adjudicate some of the extension. They can just defer to the prior approval. Or they can actually weaponize some of the language in the new rule that can be used against the students, including the status maintenance documents. So I would say there's quite a lot of uncertainty there. But definitely, given the new rule and what happened during the first Trump administration, those who are working for, let's say, a lot of the staffing agencies, like the IT consulting companies, those who work at a third party work site. So they do not work directly for the employer at the employer's work site. Instead, they are sent to a third party and work at the end client's work site. Those kind of cases will be very strictly scrutinized. That's what I see in the current new rule, and that's also what happened in the last Trump administration. So for the O1, as we previously mentioned, some of the interpretation has been relaxed by the Biden administration. Whether Trump would undo all of those, we don't know yet. But we don't feel like this is a priority for him because O1 should be, for those with extraordinary ability. So they're very talented people, right? So that shouldn't be a target, but, it's arguable who's really extraordinary, right? So we don't know yet. There hasn't been really much information on this during the first Trump administration. I don't think they really did anything to O1. So if they just keep doing nothing, that is good. Okay. EB1A, EB1B, it was tightened during the Trump 1.0. Hopefully, they won't do that again. Hopefully, they will just leave the Biden administration's policy update there, but they can revoke it, and that can be done fairly easily. They can just revoke that overnight. EB1C, not much change last time. All these years, not much change. But documentation-wise, yeah, currently USCIS does require more documents than before. Perm, actually, as mentioned, this is something tightened, more strict during the Biden administration. So whether the Trump administration 2.0 would make it easy, I don't know, but it can be more tough for the big techs, right? They've already suspended the program. What can be worse than that? So we will see if there's going to be any good news on the program. NIW, initially it was relaxed, but then it subsequently also tightened. So I would say it is at a point where, it's not as relaxed as 2022, but it's still not too bad. But it's not just because you work in a critical field, you will automatically qualify. Not because you have like a STEM master or PhD, you're going to be qualified. You still have to prove your individual proposed endeavor and the national importance of your specific endeavor. And EB5, the new law was passed in 2022, so the EB5 market is very active right now. However, just want to give you a heads up that the source of funds adjudication has been more strict. So USCIS has been really more strict with the source of funds. Good news is there has been some recent court ruling, clarifying some of the standard of review for source of funds, stopping USCIS from going back, like tracing all the funds back indefinitely, right? But still overall, I would say it is more strict than like say back in 2015 or 2016. All right. So that's a very, very brief and quick overview of some of the changes to expect. We are gonna probably go to the Q&A sessions now.
Absolutely. Thank you so much. I will go ahead and start sharing the questions that we have. All right, I hope everybody can see my screen. Let's go to question number one. So I'm planning to enroll into a graduate program. What happens if I apply for day one CPT and work full time? Do I get a chance to apply for my OPT? This is a very regular questions we encounter on and off. We would love to hear from your side.
Yeah, I mean, if you work full time uh, with CPT for 1 year, like one academic year, then you won't be able to apply for OPT after graduation.
Yes, and then also if you did have an OPT before, if you are in the US, you previously had an OPT from your first master's, for example, you won't be qualified to get another master's OPT. You will have to be a doctoral OPT in order to qualify. Question number two. So a couple of lawyers mentioned that during the first Trump administrations, USCIS took a stand allegedly against A1 CPT. That is a violation of F1 visa and denied many H1B petitions. If something like this happened again, what should we do? First of all, let's just talk about if this is true, and then we can talk about the solutions.
Yeah, that is true. So what happened was during the first Trump administration, they interpreted some of the language in the regulation, meaning that if you have used up all your OPT time, let's say, and you are enrolling in a program at the same educational level and you use CPT, that's not allowed. So whether that's CPT or OPT, as because as long as that's practical training, any kind of PT, right? Practical training, you can only have up to 12 months of practical training for one educational level. So if you want an additional practical training, you have to you know, do a higher educational level, or you just cannot use it. If you use it, you're gonna be considered violating the status. So that's actually a deviation from, the way that part of the regulation was interpreted historically. So more toward the end of the Trump administration, we noticed it gave that up already, just because maybe there was some litigation filed, or maybe there was some sort of advocacy from the like the university side, but they kind of give up that standing, like more toward the end of the Trump administration. And of course, after President Biden took office, that was no longer the policy anymore. I don't know if they're gonna bring back that interpretation again. It's possible, but last time, there was already some efforts to show like how to rebut that kind of interpretation. So it's really about how we interpret that part of the regulation. So historically, the understanding is if you have used up OPT for that same educational level, you cannot apply for OPT again. But that doesn't apply to CPT. So that's still the case right now. It's a very unusual time, in a very short period of time when it's interpreted differently.
Mm. Sounds good. Let's move on to the next one. So, Miss Meng, if my work is remote for my H1B, I wanted to go abroad to another country to work. Do I have any time limits to work in another country with H1B? And then, if I could work in another country, will it be affecting my future green card application, for example, the I-140?
Oh, there's no such fixed number of days that you can or cannot spend overseas. Um, I would say it's really case by case. So you probably need to, review the nature of your position. What kind of position is that? Is that, you know, normal? Does that make sense? What's the reason you have to work remote from China? We have to consider the specific facts in the case to understand whether that makes sense. So just like let's say maybe a couple days or even like a couple weeks overseas usually is not a problem. But if you start to spend the majority of your time overseas and only staying in the US like a couple of days a year or a few weeks a year, that may cause into question like, do you still have a bona fide H1B job in the US?
Yeah, absolutely. Good point. Next one, are employer obligated to sponsor H1B if they
No,
hire
no. It's
students?
not an obligation. So no employer is obligated to sponsor H1B visa. That's always a choice.
Okay. Next one, should spring intake students, I guess this is a day one CPT students or just any master students, defer to fall to see what Trump will do if CPT is important to funding education? I think this question's we have to understand a little bit of who's asking because not everybody could just defer and then have the legal status to be here because as an F1, you have to study or else you can't just be here forever. So, what's your take on this?
Right. I would say you really, even like, first of all, we don't know if Trump would change anything regarding CPT. And then if he does, it will take time. It's not like something that's going to happen over the night. So you don't even know, like, if there's some change, would that take place like before the fall, right? So you really have no control whether there is change or when the change would take place.
Mhm. Absolutely. All right, next question. What beneficial document will be required for next year? I guess this person is just asking in order to apply for an H1B, what beneficiary has to give in terms of documents.
Mhm. Right. So I guess maybe this is related to what we mentioned about the new rule. So the maintenance of status document would be required for any kind of employment-based petition. So it's still, the document itself, it's not too different from what's currently being requested. Like if you're a student in school, then you need to show you've been attending classes, including some of the in-person classes, right? And if you work, if OPT, you need to show that you've been working in a field that's related to your major and you haven't accrued more than 90 days of unemployment. If that's CPT, you need to show the work is an integral part of your curriculum, right? Like that's the part of the program. So depending on what status you're currently in, you need to show you comply with the requirements for that status right now.
Absolutely. Next question, very interesting. We also heard about this news that a lot of universities, or this person said lawyers also, are telling people to be cautious with international travel before after January 20th, which is when the day the new president comes out. And then this person has a H1B visa stamping schedule right before that. And he or she wanted to know, is there any possible impact for his or her situations? I think it's very, very hard to predict what's going to happen. But also,
Mm.
uh, um, if you do know any, for example, any examples of what H1B stamping was like when Trump was in his administration before, that could really share some insight into this case.
Yeah, I would say those are good, warnings to students or workers on temporary visas, just because of the uncertainty. So it's not like we know there's gonna big travel ban to be issued on January the 20th, but it could be, as Trump has mentioned multiple times, like on day one in office, he's gonna do something. He's gonna probably release a lot of executive orders, right? And he mentioned before he might bring back some of the travel bans. So which countries are going to be on that travel ban? We don't know yet. During the first Trump administration, that was called like Muslim bans, right? So it was targeting a lot of people from those Muslim countries. And it was initially blocked by the court, and then they amended and they redid it. So this time, most likely he's going to bring back, if there's a travel ban, it can be the same kind of Muslim ban as the first administration. But as some of the news mentioned, some of the other countries can be added to this ban as well, including like today China, right? So that's a possibility too. So because of this uncertainty, so it may be good for those who are students in school or who have work visas just to wait and see. Unless you have an emergency that requires you to depart the US immediately, just avoid traveling, wait a little bit to see what happens after Trump takes office.
Mhm. Absolutely. All right, goes to question number 8. If I used 3 years of stand OPT after the bachelor's, will I still get OPT after completing master's? If so, how long would I get the OPT?
Yes, you can still get OPT after master's. So that's a higher level of education. So you will still be eligible for OPT. And if the master is a STEM major, you can get the additional 24 months STEM OPT as well. But you will only be able to get the STEM OPT extension twice in your life. So if let's say after master, you go on to a doctor program, right? Even that is a STEM major, you won't be able to apply for the additional 24-month STEM OPT extension the third time. That's not allowed.
Absolutely. All right, next question. What are the difference and advantages for F1 visa students applying for H1B when comparing to uh, other students, other people coming from internationally to the H1B? I don't know if there is a majority of difference, but this person wanted to know your take on this. I guess the difference between applying for H1B with an F1 and then applying for H1B directly through another country.
Okay. I am not sure if I understand this question correctly. The way I read this question is comparing those who are currently in the US uh, in F1 status versus those who are currently outside the US, sounds like,
Right.
right?
Right. I
And
think.
who will apply for H1B visa at the consulate. Well, the difference is for those who are currently in the US, if their change of status is approved together with the H1B petition, their H1B status gonna kick in from October the 1st automatically, and they can start working immediately. But for those who are located overseas, after the H1B petition approval, they will have to, book an interview, like a visa interview with the consulate, right? So that would depends on how busy the consulates are. Especially summer, because the consulates usually would prioritize student visa. Sometimes there might be some wait time for work visa scheduling. So there's some uncertainty there. And after the visa interview, Sometimes, depending on the company, the beneficiary's background, certain majors, they might be subject to some additional review, which is usually called the administrative processing. So that can be as quick as like maybe 2 weeks. It can be as long as 6 months or even longer, 1 year. So if you are applying from overseas with a post, it just creates more uncertainty because there are still extra layers of review after the petition approval.
Mhm. Absolutely. So I think for timing's sake, we're approaching the end of today's sessions. We wanted to do one more questions, and then if you do have additional questions, feel free to scan the QR code. We can connect you either with the attorney or talk to our consultants if they can help. Let's just do one last questions. And this is actually a good question too. So if I do CPT part-time for less than a year or any durations, if I do part-time CPT, will it reduce the time for my OPT after the CPT?
No, that doesn't affect the use of OPT.
Okay, sounds good. But also the bottom line is that if you do full-time, which is more than 20 hours, more than a year, which is 12 months, you are ineligible for OPT. Even if you don't have a master OPT before, you still aren't eligible for OPT again if you
That's
do
right.
that. Okay, I guess this is everything for today. We still have some questions we wanted to get back to you guys, hopefully in another sessions. And thank you guys for answering the polls. We do collect some results of what people are interested in. So I'll put together another webinar with Attorney Meng. We are aiming to do a sessions mainly just focusing on H1B changes and new rules and possibly what Trump will do to H1B in the upcoming year. So in the upcoming January, we want to put together a new webinar. So definitely come in into that one if you're interested. And thank you so much, Attorney Ming, for today's sessions. We learned a lot. Thank you.
Thank you for having me, Ryan. Thank you, everyone. Happy holidays.
All right. Happy holidays, everyone. Thank you. All right. Bye-bye. Have a good night.